Hola a todo el mundo y bienvenido a mi canal. Yo me llamo Sirey. Soy una abogada afro-latina licenciada practicando en las leyes criminales, pero como todos ustedes, a mí me fascina cuando estamos hablando de casos de crímenes reales. En este video vamos a hablar del caso. Bueno, espérate. Vamos a seguir hablando del caso de Vallow Daybell. Si quieren más video en español, nada más dime allá abajo. Hi everyone and welcome back to my channel. My name is Desiree. I'm a licensed and practicing Afro-Latino criminal attorney who, much like the rest of you, has a severe fascination with true crime cases. Listen, you guys, when we discussed our Vallow Daybell saga on this channel, it came to my, I guess, memory, whatever, that we didn't talk about her sentencing. I would be remiss to miss this opportunity to share with you guys what happened during that date and time. So without further ado, let's get started. This is going to be the sentencing of Vallow. I'm going to go into exactly everything that Lori did because we have numerous videos on this channel for you guys to refresh your recollections should you choose. But in essence, I'll summarize. Lori was an allegedly Mormon woman who decided that she was a celestial being and that she was talking to her form of whatever is a higher power to her that was telling her that she needed to kill everyone in her life, essentially. So she enlisted the assistance of her right-hand man, who was her brother, Alex Cox. And her brother helped her carry out numerous murders to include the murders of her own 2 children, the murder of her 4th husband, the murder of her 5th husband's only wife, and the attempted murder of her niece's ex-husband. Did I get that all straight? Right, because it's been so much. Lori's a quack and she's a Looney Tune. But all that to say, she was originally charged and sentenced in Idaho for the charges against her for the crimes she committed in Idaho, which were the 3 first crimes: the murder of her 2 kids, and the murder of her 5th husband's only wife.
And so on count 1, the conspiracy to commit first-degree murder of Tylee Ryan and grand theft by deception, you're sentenced to the custody of the State Board of Corrections to serve the maximum allowed sentence, a fixed determinate term of life imprisonment with no possibility of parole. On count 3, the conspiracy to commit first-degree murder of Joshua Jackson Vallow and grand theft by deception, you're sentenced to the custody of the State Board of Corrections to serve the maximum allowed sentence, a fixed determinate term of life imprisonment with no possibility of parole. And on count 5, the conspiracy to commit the first-degree murder of Tammy Daybell, you're sentenced to the custody of the State Board of Corrections to serve the maximum allowed sentence, a fixed determinate term of life imprisonment with no possibility of parole. Finally, the court will address count 7, which is the charge of grand theft. On that charge, court is going to sentence you to a fixed determinate term of 5 years of prison, followed by an indeterminate term of 5 years of prison, for a total 10-year term of imprisonment on the grand theft. Court will next consider whether sentences should be imposed consecutively or concurrently. I'm a pragmatic person, and I've struggled with the point of a consecutive sentence when in Idaho, a life sentence is just that, a life sentence without parole. And I've thought it through. However, when I looked at this case and the more I thought about it, I've determined that because there are 3 separate murders with 3 separate victims that occurred at 3 separate times, then running counts concurrently would not serve the interests of justice, because those crimes all need to be taken into account separately and distinctly and individually. And you need to be held accountable separately for each of the 3 murders. So on those counts, the court will run consecutively the count 2 murder of Tylee Ryan, consecutive to count 4, the murder of Joshua Jackson Vallow, and count 5 will run consecutive to count 2 and 4, the conspiracy to commit first-degree murder of Tammy Daybell. So 3 consecutive life terms of prison. The remaining counts will be concurrent to the counts that are consecutive.
She then was extradited back to Arizona to face trial for the murder of her fourth husband and the conspiracy to commit the murder of her nephew. These two trials, the Arizona trials, Lori decided to proceed pro se.
Good morning, Your Honor. Katie Staub for Trina K for the state.
Good morning, Your Honor. Pamela Hicks and Robert Abernathy on behalf of Lori Vallow Daybell, who's present and in custody.
Can you tell me your name and date of birth, please?
Lori Daybell, 6/26/1973.
All right, thank you. We're here for a status conference. You've been found competent by two separate healthcare providers. Is it your intention, ma'am? You had expressed earlier that you would like to represent yourself.
Yes, sir.
Is that still your intention?
Yes, Your Honor.
And if you guys will remember from our previous discussions, pro se merely means she wanted to represent herself. She decided to represent herself. And unlike a lot of you guys who just disagree with me on this point, I don't think she did horribly when it came to opening statements necessarily.
Ladies and gentlemen of the jury, I have been charged with a crime, a serious crime. And the only question here is, did I commit this crime? Conspiracy. Conspiracy is an agreement between two or more people to commit a crime. Okay. There has to be an agreement. There has to be a plan. The evidence in this case will show that Charles Vallow and I got married in February 2006. It will show that it was my fourth marriage and Charles' third marriage. At that time, we each had two children. I had Colby, who was 9, and Tylee, who was 3. Charles had Cole, who was also 9, and Zach, who was 7. The evidence will show that our family moved from Austin, Texas to Chandler, Arizona in 2009. The evidence will show that Charles and I adopted our great-nephew, JJ, who was born in 2012. It will also show that Charles and I were married for over 13 years and were raising 5 children. The evidence will show that I was a licensed cosmetologist and worked as a hairstylist for 20 years while we lived in Austin, Texas. The evidence will show that Charles was a licensed life insurance salesman and worked as an independent contractor, selling life insurance policies and annuities, and owned his own business. The evidence will show that Charles and I purchased life insurance policies early in our marriage, and Charles had them issued to the maximum amount possible to each of us. The evidence will show that Charles was 17 years older than me, and that because of Charles' age and an issue that he had with high blood pressure, the maximum amount of life insurance that could be approved for Charles was $1 million. The maximum amount of life insurance that I could be approved for because of my age and my health was $2 million. The evidence will show that throughout our 13-year marriage, that we always had life insurance policies. When a 10-year policy lapsed, Charles would shop for another company who would approve us for the maximum amount of life insurance. The evidence will show that this was Charles' job. This is what he did. I helped him in this business, and this is what he did. The evidence will show that in 2016, Charles repurchased a new $2 million life insurance policy on me, and he was the sole beneficiary. The evidence will show that Charles and I had a happy marriage for 13 years. That he was, in fact, a baseball player, and that he played high school, college ball, and AAA ball, and that he was, in fact, a left-handed pitcher, a southpaw, they call him, but he was a right-handed batter.
I think there's a lot of procedural things that if you're not an attorney, you just don't understand. But I think she did the best she could, and it just kind of is what it is. She was going to get convicted no matter what because she's guilty of sin. Okay, point blank, period. Y eso es todo, okay?
What else did you talk about on your date?
Lots of things.
Like what, for instance?
Life, kids, the church, lots of things.
Okay. Did he tell you about anything about our other 4 children?
Yes,
So you knew that we did have 5 children as well?
I did.
Okay. Did he talk to you about my daughter, Tylee?
He did.
Did he talk about his relationship with her?
I don't recall that.
Did he talk about the contention in his relationship with my daughter, Tylee?
I don't recall that.
I'm sure you don't.
I'm going to object to comments by the defendant made after questions testifying.
Sustain the objection.
Now, she was convicted of the charges against her for those two Arizona trials, and the court held sentencing for both of them on July 25th of 2025. As is typical, we heard from numerous parties who decided to speak on behalf of their loved ones for the heinous acts that Lori put them through. I don't want to talk about everyone that spoke necessarily, but I do want to talk about Kay Woodcock's statement to Lori and the statement that Lori gave herself.
I am Joshua Jackson Vallow. I am the son of Charles Vallow. I should be 13 years old now, but I'm forever 7. The impact of my father's death was my murder. And Judge, it is 13 years today that JJ's adoption was finalized, and they moved him immediately right away to Hawaii. And I hope you remember that. I trusted you!
If you guys will remember, Kay Woodcock was actually the sister of Lori's 4th husband, but Kay was also the grandma of the child that Lori and Charles adopted, JJ. So it's a lot going on here. It's a lot going on. But Kay's raw emotion was a lot. It was a lot. I commend Kay for being able to speak so bravely, but I also think in certain circumstances, the court wouldn't allow such an outburst. I don't know. I think it depends on the judge. Everything's very judge specific. Let's take a minute and let's go like this. You guys remember Judge Everett from Donna Sue Adelson's trial? Judge Everett ain't going for none of this. He ain't going for none of this. There will be decorum in his courtroom, right? So I'm a little surprised, I guess, that her outburst was allowed, but her feelings are valid. Everything she said was valid. Lori is a monster. She destroyed Kay's life. But let's talk about what Lori herself decided to say to the court.
Would the defendant like to address the court or present any witnesses?
Yes, Your Honor. Can I remain sitting?
Go ahead.
Representing myself at these 2 trials was a constitutional right that I exercised. I could not have done so without my team. Annalena Ramirez, my paralegal, Jeff White, my investigator, and Pamela Hicks and Robert Abernathy, my advisory counsel. I acknowledge their diligence and hard work in helping me exercise that right. They worked tirelessly, and I appreciate them. Representing myself, I have learned much about the law through this process, and I'm grateful for the knowledge that I have gained. Knowledge is eternal, and it is only love and the knowledge that we acquire in this life that we take with us into the next. I have studied the rules of law, case law, and the like. I was amazed and enlightened as my understandings were completely changed from before I started this process. Before this long court journey, I only had basic understanding of the judicial process. I was of the understanding that both parties would be able to get up at a trial and each tell their side of the story, but I soon learned that the rules of law do not allow that.
Actually, they do.
The process is much more complex than that. It is not designed for that, although the Constitution of the United States was designed for that. The rules of law negate most of that. As a defendant, I was precluded from calling several witnesses. Other witnesses for the defense were precluded from testifying things that they did witness. As a defendant, I was precluded from asking law enforcement specific questions. I was also precluded from admitting documents that the state turned over to the defense as discovery. The founding fathers of this country did not intend for the rules and laws of trial that have been implemented into this justice system to make it impossible for the accused to defend themselves. Their objective was quite the opposite. They advocated for a fair and impartial and speedy trial. It was never their intention for people to be sitting in jail for years and years waiting to be tried while the state continues to try to gather new evidence against them. This is what our unjustice system has become. Men and women sitting in jail for years and waiting to be heard. The constitutional right of life, liberty, and the pursuit of happiness thwarted. My case is not unique. There are many here in Maricopa County that have been in jail almost 10 years waiting to be tried. The conditions of this jail are not for long-term confinement. You do not have access to direct medical care. You do not have access to proper nutrition. You do not have access to sunlight. You do not have access to decent dental care. In fact, when you have been in Maricopa County Jail for 1 year, they come to your door and offer you a vitamin D supplement because you have not been in the sun in a year. Imagine this for years. It is inhumane. The state of Arizona, according to the laws, since I am a prisoner from another state, only had 90 days in which to give me 2 speedy trials. That's 3 months. I arrived here at MCSO on November 30th, 2023. That is over a year and a half, 20 months specifically. That is over 6 times the amount of time it should have taken for me to have these 2 trials. But Arizona leaves this law up to the judge's discretion, and the judge has the power to extend your trial at his will. Even though the 6th and 14th Amendment of the Constitution of the United States proclaims otherwise. 98% of all cases in Maricopa County end in plea deals where the accused plead guilty. And I'll tell you why. It's so miserable in that jail that they plead guilty so they can go to the prison and have decent food, decent sunlight, and a chance to live. 2% of all cases in Maricopa County that actually do go to trial, of all the cases that actually do go to trial, only 0.2 end in acquittal. That is 1 out of 1,200 people who go to trial go home.
That's actually not the correct stat.
Is that a system designed to convict you? The rules of law governing trial assure that. As you witnessed in my 2 cases, the judge supports the state to achieve this outcome. So here we are. The state of Arizona has accomplished its intention. 1, to extradite me from Idaho. 2, to convict me. And 3, to add to my ledger of lifetimes. The state used countless taxpayers' money to transport me, house me, millions of dollars to wrongly convict me on 2 charges that they made sure judicially that I could not defend myself against. I know political aspirations, raises, and job promotions were at stake. So congratulations. I was convicted in the media long before I went to trial. We all know that there was no way for me to come to Arizona and get a fair, impartial, or speedy trial. And now that fact has been proven.
I think Lori Daybell is one of those people you can't reason with. I think she's illogical. I find her to be vile. I think she's sickening. She's a horrible human being. And in every step of the way throughout her entire statement, she decided to play victim. Woe is her, right? Not woe are the people that you killed and the family members of the people you killed. Woe is her. Are you done adding on life sentences? Are you done killing, beloved? She's a crazy Looney Tune, and I don't really have much respect for her, but I wanted to end our saga in discussing her and this trial and the sentencing. So, here you have it. Tell me what you think of her statements down below. After numerous people spoke, to include Lori and Kay, Judge Justin Boreski delivered the court's remarks, as well as imposition of Lori's sentence.
In short, you should never be released from prison. Eventually, the camera that you seek out so much, the media requests, will lessen over time and you'll fade into obscurity. As to count 1 in CR 2021-001704, the court orders you to be sentenced to life in prison with the possibility of parole after serving 25 calendar years. This sentence would run consecutively to the District Court of the 7th Judicial District of the State of Idaho in Fremont County, case number CR 22-21-1624. As to count 1 in CR 001-242-001, it's ordered that you be sentenced to life in prison with the possibility of parole after serving 25 calendar years. That sentence also, due to the number of victims you've created in the 2 cases, the immeasurable harm you've inflicted on many, it's ordered that that run consecutive to CR 2021-001704. Because these sentences are consecutive to one another and consecutive to the Idaho case in which you are currently serving a sentence, you're giving 0 days credit for time served.
As we all know, as far as first-degree murder is concerned, there's really no option she's going to be doing life. So yes, she has all of these life sentences to be served consecutively, but like, she did this to herself. I feel nothing for Lori. I don't even know if she feels for anyone other than herself. Lori's a selfish person, and she's right where she belongs. You guys, this is another video that I wanted to just make because we needed to conclude our saga. There's a few other videos that I have in the works for you guys, but they're going to be a lot longer and a lot more document intensive. I wanted to make sure to, I guess, give you guys a break in between those and just do like a little splash here and a splash there of something we could just discuss a little quicker. But that's it for this video. So let me know all of your thoughts down below. As always, thank you guys so much for watching. Please be sure to like, comment, share, and subscribe. Until next time, y'all take care.